Welcome to everyone. Uh, Welcome to the first PEP program of 2025, where we're going to explore privacy policy in the new administration. I'm James Cooper, a professor of law here at Antonin Scalia Law School and the director of the program on economics and privacy. PEP is a division of the Law and Economics Center, and our mission is to inject sound economic analysis into privacy, data security, and other competition and consumer protection issues facing the digital economy. So today, we're lucky to have joining me for this discussion two leading experts in this field. Maneesha Mithal is a partner in the data privacy and cybersecurity practice at Wilson Sonsini, and before that, she spent several years as a director and a deputy in DPIP at the FTC. Adam Kovacevich is the founder and CEO of the Chamber of Progress, and before that, he's worked in various public policy roles and for major tech firms. They both have very impressive resumes. You can check out on your own on the internet, I'm sure. But I would say we couldn't ask for a better pair to help us explore what the next 4 years might mean for privacy policy. But first, before we turn to what we might see in the future, I'd like to take a little stock of what we've seen over the last four years, focusing on the FTC in the privacy area. So, Maneesha, I'd like to turn to you first, as someone who practices this now and advises clients, and has actually, if my memory serves correct, you were actually part of the Con FTC for a couple years before you left to the private sector. So, just kind of a broad question: what do you see as the biggest expansions of privacy, as it relates to, say, Section 5 in the FTC during the Lina Khan's FTC?
Yeah, thanks, James. I think that's a really interesting question, and this may be a kind of controversial take, but I don't view the Khan FTC as having expanded privacy authority particularly. And so I think it's been kind of standard among and across Republican and Democratic administrations. And I think we've seen that in the form of bipartisan votes. Things like the fact that you need to get consent from consumers before collecting and sharing location data, getting consent from consumers before collecting and using and sharing health data, children's data. So these have always been priorities of the FTC, protecting particularly the privacy of sensitive information. And so in terms of case selection, in terms of counts in the main, I don't see a lot of difference between Khan and prior FTC chairs. On the enforcement side, we'll talk about rulemaking and AI a little later, but I think on the enforcement side, the only change I've seen is kind of the expansion of this idea of collecting and slicing and dicing sensitive information and categorizing people by protected characteristics. We saw that in the Gravy Analytics and Mobile Wallet case, that was a count of unfairness that we saw that now Chairman Ferguson dissented from. But by and large, there's been a lot of bipartisan votes on privacy issues. I think where the difference was and where Lina Khan did extend privacy somewhat was in the remedies. So things like the Drizzly case, where individual liability for the CEO was extended. Things like bans. So ban on anonymous messaging app directed to kids in the NGL case. A ban on advertising to kids and teens in Meta. A ban on targeted advertising in health apps. So those kind of bans, individual liability, very broad retention and deletion requirements. I think that's another thing that Chair Khan extended on privacy. So I do think lots of differences in terms of remedies, but fewer differences in terms of case selection and counts and what constitutes unfairness or deception.
Thanks, Maneesha. Adam, do you want to add anything?
Yeah, no, I think it's a great insight, and it's interesting because I think compared to other things she worked on, my sense was that Lina Khan was far less interested in privacy itself than other topics. We know that antitrust is her passion. We know that they were very interested in reviving Robinson-Patman Act. They were very interested in pricing issues, more near the end, pricing issues, fraud, and privacy at the bottom of the list. But I thought this was interesting because Sam Levine, who is the head of the Consumer Protection Bureau, gave an interview last week on his way out, and he said, that he had said at the beginning of his tenure that notice and consent had been a failure. And I think that was very interesting because we've seen over the last several years, particularly on the far left, this idea that notice and consent is a failure because consumers could never know all of the things that companies are doing in the background, kind of based on a sense that companies are sort of inherently predatory. And his response to that was that that he thinks that during the he felt that during the con years they used these remedies that Maneesha was talking about to tackle data minimization, limits on sensitive data. I thought that was that's absolutely true, and I agree completely with Maneesha because I think Khan in some ways cared more about the remedies. Like, can we use a remedy, frankly, to kind of advance our general war on corporations? I think is, and I think, like, for example, I suspect Khan was way more interested in the novelty of holding executives personally liable than she was what they were, like, the original reason for holding them liable. I also think one of the more interesting moments in the Khan years around privacy was the effort to revise the Facebook consent decree and to use that to reopen it into a broader restriction on kids advertising. And I found this interesting because there was division. And Alvaro Bedoya, one of the Democratic commissioners, said, look, I'm not sure we have the authority to do this. It later came out that he had been pressured by some of Khan's allies on the left and faced a lot of pressure and blowback for his statement. More recently, this case has chugged along, and at the commission level, and now Chair Ferguson had actually recently as 2 weeks ago, agreed with several of Meta's arguments about the FTC's legal ability to modify consent orders. Didn't completely agree with Meta, but criticized the FTC's handling of the case. So that to me has been another notable moment of privacy enforcement.
Well, thanks. I think these are great insights. And one thing that leads me to what both Adam, both you and Maneesha were talking about is on the remedy side. So, kind of a follow-up question to this is, how durable do you see any of these changes? So, I think about, not to get into the weeds too much, but I guess if you're ever going to get into the weeds, maybe this is the time to do it. You look at the counts, and I believe it's in either Mobile Wallet or Gravy Analytics, or maybe both, where it's unfairness actually to categorize, take data and categorize it, and it's unclear. I think there's also two counts. One, it looks like maybe it's unfair to actually just use location data, and because there's another count with using location data without consent. So, reading the tea leaves is, again, these are consent orders. These are consents. These are not litigated complaints. The FTC gets to write the complaint in these cases. And then when you look at the remedies in some cases where I believe BetterHelp stands out to me, where part of the remedy was it appeared that even with consent, you could not use these data to do target advertising. And I think there are a couple other consents that were sort of along those lines. So these are done both in remedies, they're done in complaints. None of this is litigated. How durable do you see this going forward, since this is not actually a commission decision, let alone something that was done on the outside by a court? Maneesha, I'll turn to you first.
Yeah. So look, I think that what we're seeing is, what we used to say when we talked about privacy, when we talked about the FTC, is that the pendulum did not swing too far in either direction when there was a change in administration. And I think now, I think the FTC replicates the polarization that's taking place in Washington. And so I think that in terms of durability, I think we're going to see a situation where we are going to dial back these remedies. I think I think one of the kind of unique things about having a sitting commissioner elevated as chair is that we've seen his statements. We don't have to guess. He voted against those counts in Gravy and Mobilewala. He has signaled that he is not interested in using the FTC Act as a vehicle for anti-discrimination. And so I think, there's certainly, these requirements are certainly durable as to these companies, but in terms of the message that they send to the broader marketplace, I think, we're getting questions from clients, hey, are we now under free-for-all? Now, I wouldn't say you're now under free-for-all, but I don't know that this commission will follow the remedies that the last commission put out. Again, I don't think the counts are necessarily that different. And if you look at the counts, the count is not, it is unfair to advertise based on health data. The count is, it's unfair to advertise or unfair to collect and use health data without consent. And then there's a count about, failing to make reasonable efforts to protect health data, which are consistent. It's the remedy that's the ban on targeted advertising to health data or the ban on collecting location data. And I think those pieces are not going to be as durable.
Adam, do you have anything to add here?
Not a lot to add. I agree with Maneesha. I don't see them being as durable. It's also notable to me that in the privacy area, Khan's FTC was more willing, particularly at the end, to strike settlements, when in the antitrust area they were very anti-settlement. That is a very interesting contrast, but completely agree. And I do think it's given us a roadmap for how Andrew Ferguson will operate. Although I think there are some tensions in his record on this issue. We'll get into that, I'm sure.
Okay. The last thing I want to talk about before we really start to get into what we can expect maybe from the new administration, and maybe it's a nice bridge, is to talk a little bit about AI. I mean, that's what everyone's talking. You can't, have a webinar without mentioning AI. Clearly in the Biden White House, they released AI principles. There's a lot of work going on in the executive branch. A lot of agencies, the FTC included, issued kind of a joint statement saying that they're expressing how they're going to use their various legal powers to help protect consumers in the face of AI. Again, zooming in on the FTC, we saw some what I would call maybe run-of-the-mill type deception claims, but there seemed to be a big dividing line between, and it wasn't necessarily AI specific, but it had to do with the discrimination in Section 5. We saw this actually in ECOA cases. We never saw it actually rear its head in an AI case that I can recall. But I guess I'll ask the same question as we talked about in privacy. Do you think the commission did anything new in the AI field? Did they do anything novel? Maneesha, I'll send it over to you.
Yeah, so I think the way you asked the question, James, I completely agree with you. There are the more kind of run-of-the-mill deception cases that stand for the proposition that you make deceptive statements about AI, that's a violation of the FTC Act. I think there's bipartisan consent around that. I think there are a couple of cases where the FTC did move the needle on AI. And also I want to talk about rulemaking on AI. So in terms of enforcement actions, there's the Rite Aid case, where I actually think the facts of, that at least the public facts on that case are pretty egregious. But they used kind of unfairness to get at Rite Aid's facial recognition technology that discriminated against certain protected classes. So I do think that's something new. I think the second new kind of case was the Writer case. And Writer is a generative AI company that helped consumers develop scripts. And you can use it as a starting point for various types of essays or scripts or things like that. And one of the things the FTC took issue with was that Writer allowed consumers to write unlimited reviews of products. And the FTC said, the majority said, because you provided the means for bad actors to submit fake reviews, that was an unfair practice. And I would say there was a fairly scathing dissent from Chairman Ferguson and Commissioner Holyoke on a number of fronts, saying, number one, you've proved no evidence of actual harm in these cases. And number two, this is a neutral technology. this is a neutral technology that can be used in ways that can be beneficial or that bad actors can use for nefarious purposes. And it is inappropriate to hold this intermediary liable for those things. So I think those are the kind of two enforcement actions where the FTC kind of was setting its agenda on AI beyond deception. And then on the rulemaking front, there are kind of two things we saw there. One is the commercial surveillance rulemaking that was issued. The advance notice of proposed rulemaking was issued in August of 2022. Promised to target things like AI discrimination. That is now defunct, as far as I would guess. And then the other rulemaking that the FTC initiated was this AI impersonation rulemaking. So again, they took this non-controversial prohibition on impersonation fraud, and they issued a supplemental notice of proposed rulemaking where they proposed to hold generative AI companies responsible if they knew or should know that impersonation fraud is taking place on their platforms. And I believe that's going to be dead as well in the new administration. But those are just some ways in which the Chair Khan's administration signaled an intent to regulate AI in ways that we had not seen before.
Yeah. Thanks, Maneesha. That's, I mean, it's interesting while you're talking about this. I hadn't really thought about it so much as to focus on what I'll kind of broadly call vicarious liability of these AI companies. It reminds me in a different context and dates me some of the Sony doctrine in copyright law, where the Supreme Court had to balance the idea of, well, you've got this neutral technology, and we saw that also in Napster and peer-to-peer networks. Is it capable of substantial non-infringing? Then we're going to put the thumb on the scale of innovation. We're not going to let these innovative companies be liable. Here we kind of see a similar balancing that needs to probably be done here at the FTC. So Adam, I'll turn to you to get some thoughts on AI in the Khan administration. And you brought up the commercial surveillance rulemaking. I wanted to ask about that, but I guess as the kind of also to you, Adam, do you agree with Maneesha that this is probably dead, that we will not see an NPRM or anything else in this area?
Yes, I think the commercial surveillance rulemaking for the last 4 years has basically been engaged in a tango with Capitol Hill about, and was meant to sort of serve as like a little bit of a pressure to get Capitol Hill and Congress to move on comprehensive privacy legislation, which they made some efforts on, but which ultimately ran aground, I think, for a bunch of reasons, not least of which was, kind of like the inherent fragility of a compromise where, Republicans compromised on private rights of action, Democrats compromised on preemption a bit. So I do think that's dead, particularly because I think during that process, Congress pretty clearly signaled to the FTC that it didn't want the FTC to move forward unilaterally with an area that they viewed as their own, notwithstanding their own inability to compromise on that issue. Sort of shows the difficulty, and I frankly think like it would have been difficult for the FTC anyway. But I do think all of these things that Maneesha is describing point out the gap between Khan's ambition to change things and be in front of new things and the reality of what the FTC actually has authority over, which is unfair practices, deceptive practices. And so this was one of several areas. I think labor was another area where there was sort of started off their work in this area on AI with big headlines, big ambitions, and then it ultimately became deception cases, which is not that different from old deception cases.
One area here clearly is, and again, we saw this in these used car dealers in ACOA, not in AI, but this push to try, as you said, kind of you're stuck with your legal authority, is to try to push Section 5, which prohibits unfair acts and practices. I mean, what can be more unfair than discrimination? But does it really fit as an anti-discrimination statute that again, never tested in the courts, but and certainly maybe promised in the AI context. There were various statements by various commissioners and the chair, but never really used. So let me now, this has been kind of a great overview of where we've been. Now that we have a new Chairman Ferguson, a new FTC, Maneesha, I want to turn to you since, of course, you've been there, you've run DPIP, you kind of understand the nuts and bolts of what it's like to be in the building. I'd like to just start with a simple procedural question. If my counting is correct, there's still 3 Democratic commissioners and 2 Republicans, right? One of the chair. Now one of the Republicans is the chair. And I'm not sure. I think I'd heard somewhere that Khan said she was leaving at the end of this month. So I guess we have a week where we could potentially have some mischief. But number one, what do you anticipate this next week being like? And then even if when Chair Khan leaves, it then becomes a 2-2 commission. We had something similar when Commissioner Olhausen became acting chair Olhausen, and we had Terrell McSweeney, I believe, at kind of a 1-1 for a while. What kind of power does the chair have at that point to drive the agenda before we get that 3rd Republican commissioner? So Maneesha?
Yeah, so just maybe some kind of level setting here. So Chair Khan's term, her term has expired, and but according to the rules, she does not need to step down until her replacement is confirmed. So that, hence she's there. She's, Trump has appointed Chairman Ferguson as the chair, but she can stay on as a commissioner. The tradition is for the chair to leave when the new president appoints a successor, and that successor has started. But even in the instance you're mentioning, then Chair Ramirez stepped down, but she remained on as a commissioner for a couple of weeks, and she actually voted out some things, but nothing controversial. So I think she and the acting chair Olhausen and Terrell McSweeney, they voted out matters on a bipartisan basis. It was nothing controversial. So you can imagine a world where, I think Chair Khan's public statements are such that she has said that she's going to stay to essentially clean out her office and deal with records retention and things like that. But you can imagine a scenario where the 3 Democrats decide to vote something out over the objection of Chairman Ferguson. I think there were some FTC watchers who suggested that if Lina Khan stayed, that even though he doesn't necessarily have the authority to fire her, that Trump could fire her and kind of set up a battle about Humphrey's executor and the ability of FTC commissioners to sit it well. But that's a lot of inside baseball procedural stuff. I think the bottom line here is, I think, one option is that she really does stay to clear out her office and doesn't really vote on anything controversial. I think that's kind of one door. Another door is that she forces everybody's hand by kind of voting with the Democrats. It's nothing very controversial in this last couple of days. Yet another kind of door is potentially, and we saw this when Rohit Chopra left the FTC, it's something called zombie voting, where a sitting commissioner can vote something out or move to vote something and kind of register their vote. And then there are 30 days for the others to vote, and conceivably, things could be better. So we're thinking about January 31st as an end date, but conceivably it could be kind of the end of February. That's the end date. So I think we'll get a lot of clarity in the next 10 days. But I think those are some potential scenarios. Now, to your point about the 2-2, again, in the past, I've sat at the commission when there's been lots of 2-2s, and the FTC still got a lot done, because a lot of the FTC's work does get done on a bipartisan basis. So certainly some of the more controversial things will be delayed until there's a 3rd Republican commissioner, but I think a lot of the routine things would get voted out, even if it's a 2-2.
So thank you, Maneesha, for filling in 2 things on my bingo card: Humphrey's executor and zombie voting. So that is fantastic. Let me pose a follow-up to you, Maneesha, and then I'm going to let Adam jump in. But I thought, again, since you have the expertise and actually, sort of managing and dealing with budgets and that sort of thing, we hear a lot, and it seems to be the talk of the town in some ways about the Trump administration coming in and kind of full throttle. We're going to stop the bureaucracy, the federal workers, right? And so to the extent there is, so one lever is of course money. Another lever is, you've got hiring freezes. I think that was automatically put in. Then money could be cut off. Now there's everyone has to come back to work in a week or something like that. I know that, what do you see that as far as impacting the FTC's ability to get the job done, whatever that job may be, whether it's a Ferguson vision or a Kahn vision, but to actually do the work under a tighter budget and maybe stricter, no more work at home. Everyone comes in. How many people leave? What is the FTC just going to be able to accomplish?
Yeah, no, so I think that, there have been periods of leanness, over my 22 years at the FTC. And we always said, well, we're going to do more with less. And I think now, there may be, we're going to do less with less. And so I think to your point, there is that mandate for people to come in 5 days a week. There is, although I will say, like, sometimes the application of executive orders to independent agencies is somewhat unclear. So, we're not quite positive on what's going to happen. And there's, even in that executive order requiring federal workers to come back in, agency heads have some discretion. But I think it's fair to say that, there will, given the hiring freeze, given, the inability of people to backfill positions, given, if people are asked to come back to work, I think the FTC will certainly have less and will likely be able to do less with less.
Yeah. Well, again, that was a kind of a Humphreys executor adjacent answer. I like that, talking about the distinction between the executive and independent agencies. So fantastic, Maneesha. Adam, did you have anything to add here on kind of the nuts and bolts of the operation of the FTC under potentially leaner times? Or
no, except to say that I think Ferguson may not mind this shrinking. People leave the FTC due to a work from the office mandate. That might not be terrible. I do think it kind of points out, again, some of the tensions. Ferguson's in many ways is a smaller government person, but there are areas where he does want to do more, including novel things at the FTC.
Yeah. So let me turn now, Adam. I've got you turned to, back to privacy policy. Okay. It used to be, at least in, when I was kind of growing up at the FTC and getting started in privacy and consumer protection, thinking about it, it used to be that Republicans tended to push back on privacy regulation, Chamber of Commerce, the usual suspects, and it was more of a Democratic, but this appears to have changed. It seems that maybe so that everyone seems to be in favor of privacy in some ways now. So I'll ask you, as someone who knows a lot more about Capitol Hill than I do. I mean, where are the fault lines in privacy regulation these days? Where do they lie? Because they don't seem to lie where they did, say, 10 years ago.
No, I think that's right. I think the reason why it got scrambled is because the tech industry became seen as the main industry that privacy regulation impacted, even though that's not true. I think there was a period of time on Capitol Hill where members of Congress supported a federal privacy regulation because they viewed that as the way of constraining the power of big tech in particular. The problem with that, and I think they soon encountered this, was that, if you're really trying to protect privacy as a value, then there's no reason why we would write legislation that would only constrain the tech industry's approach to privacy. There's large companies that are not tech companies collect lots of data and have an impact on people's privacy. So it's not a very principled way of going about it. And I do think that, frankly, this is one of the things that that caused privacy legislation to ultimately run aground in Congress, because at the time, I think when it started, it was like, oh yeah, we Democrats, we agree, we both hate big tech. We're going to go after them, and we're going to constrain them by passing privacy legislation. And then when they got into the particulars of it, and it became things like, well, are we not going to preempt all of the state privacy laws? There are not just Democratic states that have passed state privacy laws, but Republican states, and you started seeing pressure from red state governors saying maybe we should just leave these state laws in place. The other thing that I referenced earlier is, a pain point for industry has been private rights of action, and so that became part of the compromise, which is not something that Republicans have normally supported, an expanded right to sue by individuals. But on the other hand, I think one of the big things that changed that is Trump. And Trump loves suing individuals. And so I do think like the Republican aversion to private rights of action has absolutely faded over time. So I think that's impacted kind of where we end up today.
Maneesha, do you have anything to add here?
Yeah, it's interesting, James. I remember the days you were talking about when like privacy was, Democrats were for privacy legislation and Republicans were against privacy legislation. I think one of the things that also kind of turned that tide or changed that is that at some point, given the proliferation of state laws, given CCPA, I think industry started to lobby for federal privacy legislation that would preempt state laws. And under Trump 1, we saw that the Trump administration actually supported federal privacy legislation. So I do think that the bedfellows have changed, and I wonder if given Republican control of both houses and the executive branch, if there is not conditions are not ripe for having federal privacy legislation. Now I keep saying that. I've said that for the last 20 years, but but I don't know, that I think that's a change that suggests that maybe it might be something that's taken up. But again, Adam points out the headwinds to that as well. That kind of opposition from states, even including red states. So we'll see.
No, that's interesting. The interplay. I think that's an interesting insight that maybe Republicans are less allergic to a private right of action than they used to be, in sort of the interplay of the states, which we'll get to in a minute. But I want to, I guess, kind of tangentially related is the relationship here between that we see, and we talk about how privacy is all of kind of about the tech companies, is the relationship between content moderation, First Amendment, and the antitrust. It seems like it's almost a litmus test to be part of the new administration to say that the tech platforms are squelching conservative speech, and we need to use the powers we have, in particular antitrust, but also consumer protection or privacy, whatever you have, to go after them. In fact, we saw some of that in the, I think, in the letter that was leaked that Chairman Ferguson wrote when he was kind of lobbying for the job. And we've seen that actually in the kind of the run up to Trump too. A lot of people who I think are pining for positions in the administration have been talking about this. This is a major talking point. So what I guess, Adam, do you what I guess kind of two questions. I know you're not a lawyer, but you know as much about law as anyone I know. At least know how Capitol Hill works. What are the legal and political limits here? I mean, do you think that any of this will come to fruition? Do you see any work in Congress, work at the FTC? So let me turn to you first, Adam, and then I'll move over to Maneesha.
Sure. Well, I mean, let me just say, I think Andrew Ferguson is well aware of the FTC's legal limits, but he ran a campaign to become chair where he, hit all of MAGA's greatest hits. And, so for example, I think that in his campaign documents that were ended up being published, he talked a lot about constraining the power of big tech. And I think it's almost like he's advanced kind of this like blob theory that kind of blends in, oh, they have a lot of data and I'm concerned about that. with, oh, they have a lot of power over speech, and I'm concerned about that. But it always kind of focuses on speech primarily. There's some things around targeted advertising, but this is where I think there's a little bit of a tension. And I think honestly we're going to see this in how Ferguson approaches this role, because there are clues that he is a small government conservative. You know, he has said, for example, he is skeptical about the FTC's strategy of settling consumer protection cases to build privacy case law. He also said he doesn't have a negative view of targeted advertising, that he said that he thinks it can help promote competition. He's been critical of the FTC's, what he called the FTC's attacks on online anonymity. But on the other hand, there have been a surprising number of times where he kind of seems to almost endorse the Khan view about surveillance data gathering, right? Said that that actually these companies are gathering a lot of data, blasting online platforms for invasive data gathering, even adopting the commercial surveillance term. And so like I think that like honestly, this is kind of where we'll see where he goes, because I think there's going to be attention to his desire to have sort of small government, more conservative, more humble role for the FTC, but maybe a more aggressive role when it comes to policing the power of big tech. And I think that could come up in data protection and limits on data collection and use.
So Maneesha, let me turn to you to maybe drill down on thinking of some of the legal limits here. As you're as a lawyer, both practiced in the building and now advising clients outside of the building. I know privacy and data security are kind of your main areas, but you also know enough about antitrust, I suppose, to be conversant. You worked at the FTC, at least seeped into you over 20 plus years. Is the theories here seem to be that at least on the antitrust side, that you're abusing dominance by not not providing sufficient conservative speech, right? And then I guess the consumer protection theory is maybe that you promise an open marketplace of ideas, but you're not, because there's not sufficient conservative speech. Now, and then in the background there, you've got the First Amendment. I mean, so what are there really any plausible? And I know we're not gonna. This is a whole webinar in itself, or a whole panel days worth of panel discussions. But are these in something that would actually be in the FTC's arsenal to plausibly go after? Do you think?
Based on my reading of the statute, no. And I think that this is something that former Chairman Joe Simons considered under Trump 1 when he was asked to look into these types of issues, and he argued that this was not within the purview of the FTC or within the purview of the FTC Act. So, I'm skeptical, and I also think, I think Adam alluded to this kind of internal tension in what we're seeing with Chairman Ferguson. And I think it makes it difficult to predict what's going to happen, because you see these kind of three strains of influences. Like, one is the kind of Chamber of Commerce view, the smaller government, the business friendly. Then there's kind of the second stream, which is the more populist view. And these are kind of, you hear about the conservatives, the people who kind of share certain views with Lina Khan.
I think we have a couple of those in our faculty.
Right. So that's the kind of second view. And then the third, you have kind of the traditional law and order Republican, I'm going to enforce the law. And I think we see shades of all three, but we don't know which one is going to emerge. And maybe it's kind of shade 2 to get the job. And then, kind of when he has the job, it'll be more kind of the traditional Republican administration that we've seen, or it could be that, these are really his views. So I think we'll just need to wait and see.
All right. So let me turn kind of as we're thinking about the federal lay of the land, is turn a little bit to Capitol Hill. Adam, I'll kind of, as we go back and forth, I'll pose this to you first, but then come to Maneesha for any follow-up and thoughts. Is we've got Republican Senate now. We have a House, but with a slimmer majority. You've already talked about. We both kind of talked about the elusive, ever elusive privacy bill. Do you? So I guess kind of two things on the plate here is one. Do you think that there's any chance of something like that happening in this Congress? And then, and maybe this is the second part of this question is perhaps more to Maneesha, who's lived this. Is do you see, since the FTC in many ways is beholden to the Senate Commerce Committee, do you see there being any major changes in sort of policy directions that are coming out there? So Adam, I'll turn to you first, and then
Sure.
then to Maneesha.
The short answer is no. I don't see anything coming out of Capitol Hill. And I'll just explain why. So, the House could pass a party line Republican bill, and then it would go over to the Senate, and it could get all votes of all 54 Republican senators. But in order to actually pass, it would need 6 Democratic votes. So the bill would have to actually be more of a compromise. I don't think Congress really has the muscles for broad regulatory bipartisan regulation of business anymore. Most members of Congress have never done a bill like that. And so, and I think one of the things you saw last year, the year before that, when particularly the House Energy and Commerce Committee was making some efforts at it, was why so for example, the bill that was written preempted most states' privacy laws, but it did not preempt the Illinois biometric law. Why? Because at the time it was first drafted, Jan Schakowsky, House member for Illinois, Democratic House member, was one of the key players on the Energy and Commerce Consumer Protection Subcommittee. So she wasn't going to let her state's own law be preempted. Similarly, when that bill started advancing, the California delegation started getting pressure from the California privacy regulator saying, wait a minute, we don't like this. We've just spent 2 years setting up our own enforcement authority. We don't necessarily want California's law to be preempted, even though there would still be plenty for the California enforcer to do. And so you started getting a brushback on that. And then I think you also started seeing some Republicans saying, more the traditional Chamber of Commerce types, like, why are we doing a private right of action again? That doesn't seem good for traditional businesses. So, each side had kind of conceded a lot in a bipartisan environment. We're not really in a bipartisan environment right now. And so I don't think we're going to see anything. I think you might see Ted Cruz, chair of the Senate Commerce Committee, just do a fully preemptive bill, but that would probably be a party line bill, not a bipartisan bill. And so I wouldn't hold your breath for anything coming out of Congress.
So Maneesha, I guess, same question to you about Congress. You can agree or we've had nothing but agreement here. I mean, if you want to disagree with Adam, go ahead. But I'd also like to, as someone who I know you've testified before in Capitol Hill in your FTC position, and how the Senate Commerce Committee can actually pull strings. Now we have a Republican Commerce Committee. We've had it before, but it's a new one. Do you see anything changing in the priorities or pressure points that they may be asking for?
I really don't. I think, one interesting area for discussion that we haven't really talked about is kids privacy. And so COPPA is one where, again, I think there's been and this goes to Adam's point, I think there's bipartisan support for certain principles, child privacy and safety. You see it in the Project 2025 plan. You see it, you see it in the Ferguson statements and others, that is a kind of a priority area. And so just as an example of that, the FTC on a 5-0 basis issued the final COPPA rule in the week before the Khan administration. Again, bipartisan. Ferguson wrote a statement saying, hey, I think overall this is great. I have 3 small things that I kind of do differently. And then lo and behold, there's a regulatory freeze. And the executive order says no rule that has not yet been published in the Federal Register is going to move forward until my appointee has the time to review it and approve it. And so I could see that this could be in limbo until there's 3 Republican votes and they vote on the 3 changes that Chair Ferguson wanted. So So I feel like kids' privacy is kind of an area that people trot around as a bipartisan area, particularly also, I talked about the commercial surveillance rulemaking and the AI rulemaking. Those were Magnuson-Moss rulemaking, so kind of an obscure FTC rulemaking procedure that is not very favored. Yes, so your third bingo card.
That's number 3 on the bingo card. Nice.
So that's kind of a special rulemaking procedure that the FTC hasn't really used and the Republicans don't generally favor, versus the copper rule, which the FTC was authorized to do by Congress. And so I don't think there's any kind of procedural hurdle to doing that, but I do. So I think that's just an interesting area for discussion in terms of the interplay between Congress and the FTC.
I want to turn to in our last bit of time here, turn to the states, but just kind of a quick follow-up, Maneesha, and Adam, feel free to jump in too if you want, and you'd mentioned this before, the Meta, kind of reopening the Meta settlement, and we talk about kids privacy. There's kind of, and this has been a theme, with and I'm wondering how, if you think that the new administration, will carry on with this. Is, if I recall correctly, if I got this right, is that the new Meta settlement would mean that they couldn't use, they would kind of push up the age from to like 16, right? Or it was at 18. And is that something that you think would have bipartisan support? I mean, this idea of, social media gone awry, it's ruining our kids. So here, let's just use this as a vehicle. Maybe it would be something you as a Republican chairman could tout, like, I'm saving kids from social media.
Yeah. So I don't think that the Republicans will support the Meta as the vehicle to do that, the Meta case. But again, this is where I don't know which of the 3 kind of strands will kind of emerge victorious here. But we've seen statements from then Commissioner Ferguson, talking about the excesses of data collection on teens and kids. There's the NGL case where he supported the case, this was an anonymous messaging app directed to kids, but the remedy in that case was a ban on anonymous messaging apps directed to kids and teens, and he did not support the ban. So I'd be surprised if he supported that. I think there's a lot of conflation of children and teen privacy versus content versus addiction versus scrolling versus TikTok national security. So just pulling at these threads, I don't think the kind of privacy thread is the one that's going to emerge victorious on the kids and teens.
Well, thanks. Let's in the little bit of time we have left, we've spent all of our time talking about the FTC, mostly because it is the main privacy regulator at the federal level and gets a lot of the attention. But Adam, as you alluded to, the states have been super active. Really, over, it used to be just California, but now maybe there are 16, maybe up to 20 states, or maybe it's 20 states if you take into account everyone that's considering a privacy law. And on top of that, you've had some states, I think Colorado in particular, and I think there's one more, it's escaping me, that have moved to specifically regulate AI. We've couched this whole discussion as kind of the new administration. Of course, there were a lot of elections at the state level as well. Did the 2024 election change any dynamics at the state level, and what do you see developing there? Where do you see this state privacy and AI regulation or legislation?
Sure. I think 3 big dynamics. The first is legislative. There are about 20 states, as you said, that have state privacy laws on the books. There's probably another 7 or 8 that will debate them this year. Most of these laws kind of fit within a clear spectrum. They give individuals more control over their information. They give the ability to know what a company's collected, give ability to opt out, things like that. And so what you mostly see now at this stage of that debate is states debating whether they should add to those 20 state laws. And candidly, a lot of that has sort of hinged on whether to include a private right of action. There were Democratic proposals last year in Massachusetts and Vermont that would include a private right of action. And the Vermont one actually was governed by was passed by the legislature, but vetoed by the Republican governor there. So, watch out for that, but I don't expect it to be a huge area. The second area I would just kind of call at the state level is California. So California spent 2 years setting up its own privacy regulator, the California Privacy Protection Agency. Ashkan Soltani spent 2 years setting that up. He's now left. And so I think what you're going to see this year is a couple of work streams from their agency coming into maturation. They are building a platform for giving consumers the ability to opt out of data broker collection. That's due to launch this year. They've received a couple thousand complaints from consumers. They've issued some enforcement advisories on data minimization and dark patterns. So that'll chug along, but probably more process oriented. And then the third thing, as you said, is state level AI bills. And particularly, Colorado's law was focused on automated decision making and discrimination. And that bill does not go into effect until 2026. There's a rulemaking that's been going on in California, or in Colorado, to determine the bounds of that. And in some ways, it's a little bit of a relitigation of some of the key issues there. While they're doing that, a bunch of states this year will consider their own Colorado-style laws. There's been one that's introduced in Texas, which is sort of strange because it's bizarre for a red state like Texas to have a bill that includes a private right of action. There'll be a similar bill back in Connecticut this year, and there'll be a couple of states that do that, and that will sort of edge up to privacy by focusing mostly on discrimination and automated decision making.
Maneesha, if you want to jump in on the state level as well, I'm thinking, you're obviously advising clients, and you clearly advise them with respect to the FTC, but nowadays when you're advising clients, I guess you have kind of three buckets. We haven't talked about Europe at all, GDPR, but now as you're talking to clients, how important are the states, and where do you see the states going in the future with their both AI and privacy legislation?
Yeah, I actually think that the states are going to step in a big way, and they're going to see. This is what I would guess that they're going to see, to the extent that they see a lull at the federal level or statements suggesting that there will be less enforcement on these issues at the federal level. Particularly the blue states, I think, will view themselves as having to fill in the gaps. And I think one of the, and to your point, to your question, James, we're getting lots of questions about the state privacy laws. Nobody ever says, help me develop a compliance program to comply with the FTC Act. They always say, like, help me develop a CCPA, GDPR, compliance program. So on the privacy side, lots of questions. On the AI side, one of the things I find really interesting is that, on privacy, we had like these principles that had been developed over a 30-year period. We had the OECD principles, the Fair Information Practice principles, and by and large, you see the state laws following those models, right? Whereas on AI, you see Colorado covering the high-risk AI systems and AI discrimination. You see California pass transparency and provenance bills. You see kind of the big bill in California last year that died or was vetoed by Governor Newsom on safety of frontier models. So there's not like a prototype or a model that's developing. And I think there's real questions in industry about, should we, is there a particular prototype that should be supported? What should happen at the federal level? So again, I don't think anything really is going to happen at the federal level, but those are the types of questions we're getting from our clients. And it is really hard. I mean, we always use the talking point of like patchwork when we're talking about privacy and data security. Okay. But for AI, it really is a patchwork.
That's interesting on the AI front about how it, here we are, it's the program on economics and privacy. We're talking about privacy, but so much of what AI bills, I think, are targeted at, I mean, a lot of it's discrimination, a lot of it, is sort of outside the realm of privacy, even though this is all built on data, sort of automated decision making. The last thing I guess maybe not the last thing, but kind of related why I had you, Maneesha, and you'd mentioned children's privacy. We see now big suits by AGs. There's one against TikTok for harming children. There's addictive social media law in California. Do you think, and Adam, I'll let you weigh on this as well. I mean, are we kind of at a turning point with respect to regulation of social media as it applies to children? Have we, has everyone read Jonathan Haidt's book and decided that we need to, that this generation has, and I include my kids in that. At least I have something to blame for the fact that my kids don't turn out as successful as I want them to be. It's not my fault. But more seriously, I mean, is that do you think that these type of laws and these type of sort of AG consumer protection-y type suits have traction and are going to affect any change in the social media space?
Yeah, well, I'm going to defer to Adam mostly on that question. The one thing I wanted to point out related to your question is that in the COPPA rulemaking, one of the proposals in COPPA had been to ban the use of children's data to, quote, prolong their engagement on a site. And in the final rule, on a bipartisan basis, that requirement was taken out. And maybe that was in the recognition, that was part of the FTC's recognition that they can't regulate prolonged engagement. That's not a privacy issue. And so I think, so I do think that this is going to play out at the state level, but I defer to Adam on some specific litigation.
Well, that FTC,
Adam,
very wise of the FTC to take that out. And I would say that wisdom is the opposite of what we see state legislators doing. Seemingly, all of them have read Jonathan Haidt's book, James, and want to do something about it. But the problem they keep running into is very pesky, is the First Amendment. Almost every one of these state laws that requires age verification or age-appropriate design or any of these things has essentially been enjoined because the courts have ruled that they are a speech restriction. And so I think it's and the funny thing, I don't know if it's funny, but our organization, we spend a lot of time pointing out to legislators, though, this bill that you're writing, the same identical bill has been enjoined in all these other states because of its running headlong under the First Amendment. And no state legislator really wants to hear that. And it's funny because they then go to their attorney general, and the attorney general says, yeah, no, let's try it. So the consequences of trying and then having your law enjoined because it's a First Amendment problem seem to be very low for most state legislators. So I think we're going to keep trying it, but I think they're just going to keep running into constitutional problems.
Well, I've got a question from the audience. We have 1 minute, and I think it's an easy one for you to answer. Adam, do you agree with Maneesha that the COPPA rule gets put on hold during the regulatory freeze? Thanks for any thoughts.
Yeah, I do. Although I will say this one wasn't quite as controversial in the end as some of the other things. You saw last week of Khan's tenure, just cranking out a settlement and announcement after announcement, and so I think that these things were rushed at the end. But I think it probably is susceptible. I defer to Maneesha's analysis of that, and I think it points out kind of the perils of that last minute rush.
Oh, that was my last chance to get some disagreement. This is certainly not a
Sorry.
This was no. I tried, but this has been a fantastic panel. We're right up at 1 p.m. Extraordinarily informative. Adam and Maneesha, I can't thank you enough for taking time out of your busy days to help inform me and our audience. And again, thanks to everyone in watching this. And thank you, Maneesha and Adam. I had a fantastic time.